Good day everyone. We are the group 2 and the coverage of this discussion is section 3, conditions and warranties, article 1545 to article 1560. So let's start. Article 1545. Article 1545 talks about the effect of non-fulfillment of condition. Next slide. Meaning of condition. A condition as used in Article 1545 means an uncertain event or contingency on the happening of which the obligation of the contract depends. In such a case, the obligation of the contract does not attach until the condition is performed. So, condition po is requirement involved in a contract kung saan kailangan munang mangyari ng condition so that there will be an obligation under an existing contract. Example, meron ng existing contract of sale between buyer and seller. Buyer pay a down payment and may undertaking siya to pay the balance when the seller evict yung mga squatters doon sa parcel of land. Now, the seller has 30 days to evict the squatters, but the seller failed to do so. So, the buyer has two options. Next slide. Here are the effect of non-fulfillment of condition. Number 1, if the obligation of either party is subject to any condition and such condition is not fulfilled, such party may either A. Refuse to proceed with the contract, kung saan pipiliin ni buyer na wag na lang ituloy kasi hindi naman napalayas ni seller yung mga squatters. Or letter B, proceed with the contract waiving the performance of the condition. Itutuloy yung contract kahit na hindi na mangyayari yung condition, pero babayaran pa rin ni buyer yung balance. The failure of the seller to comply with the condition does not result in the failure of the contract because the contract is already been perfected. Binigyan lang nito ng option yung buyer to refuse to proceed or proceed then waive the condition which is imposed in the performance. Number 2, if the condition is in the nature of a promise that it should be happen, the non-performance of such condition may be treated by the other party as a breach of warranty. Example, seller sells a subdivision lot and promise to construct road para may dadaanan papunta sa subdivision lot. If the seller failed to construct the road, the buyer may treat the non-performance of the promise of the seller as a breach of warranty. And warranty is under 1546. Next reporter.
Article 1546. So this article refers to expressed warranty. But first, let's define warranty. Next slide. So a warranty po in general is a statement or representation by a seller contemporaneously and as part of the contract with reference either to the character, to the quality, or to the title of the goods, and by which the promise to ensure certain facts are or shall be as held as he represents them. Warranty po ay another form ng contract. It is a legally binding commitment forming part of the sales contract na nag-a-assure sa buyer na yung certain product na binibenta ni seller ay free from defects. Ito yung assurance or promise na binibigay ni seller sa buyer na yung certain facts or condition na sinasabi niya about sa product na binibenta niya are true and will happen. I'm sure na lahat tayo have encountered warranties kapag nagpe-purchase ng goods outside. Yung warranty doon is yung representation by the seller na yung thing na ito has a certain quality or character kung saan naiengganyo niya tayong bumili relying dun sa sinabi niya. So not only the seller can make warranties, a buyer can also make warranties such as a promise to pay or any other inducement for the seller to enter into a contract with him. Warranties by the seller may be expressed or implied, but we will be focusing sa expressed under this article. So when we say expressed warranty, this is any affirmation of fact or any promise by the seller relating to the thing, and dapat daw ang natural tendency nito is to induce the buyer to buy. It makes the buyer want to buy, and the buyer buys the thing or object relying on that warranty. Dahil may warranties, nagkakaroon ng inducement relying on dun sa representation ni seller with respect to the quality or capacity ng thing. This means that the buyer has purchased the goods on the reasonable assumption that they were stated by the seller. So, effect of expressed warranty. If the expressed warranty is false, magkakaroon po ng breach of warranty. Yung seller then will be legally liable. The seller is liable for his expressed warranties kasi sinabi niya yon, which is to nag-rely yung buyer kaya niya binili yung thing. A warranty being a part of the contract of sale, it is immaterial whether the seller did not know that it was true or false. Whether or not aware si seller na still, because he expressly stated an affirmation or promise relating sa thing na binebenta niya, he is liable. When you make expressed warranty kasi, you will be held to the fact na yung sinabi mo is true and you will have to cover it kahit na you relied on information that was false but unknown to you. For example, si A nagbenta kay B ng sasakyan for 90,000 pesos, where sinabi ni A na maayos pa at maganda pa yung takbo ng sasakyan. And it is a 1977 model daw, and that it is worth about 100,000 pesos. Si B, tinignan niya yung sasakyan and tinest drive niya, and then after nun, nag-express siya ng satisfaction over din sa condition ng sasakyan kaya binili niya. Tapos, it turns out pala na yung sasakyan ay 1976 model pala and it is worth about 80,000 lang. In this case, si B wala siyang right of action for breach of warranty kasi yung inducing cause ng purchase niya is not the statement as to its model and value, kundi yung reliance ni B sa appearance and dun sa condition ng sasakyan kaya niya binili yon. Pero if yung reason ng pagbili niya ay dahil sa sinabing model ng sasakyan, then may breach of warranty tayo doon kasi it turns out mali pala yung model na binenta sa kanya ni A. So, next slide. Next, dito naman tayo sa effect of expression of opinion. So, sabi dito, a mere expression of opinion, no matter how positively asserted, does not import a warranty. Sabi nga po nun sa law on obligations na, if natatandaan nyo, na if in case daw na the opinion turns out not to be true, it is not fraudulent in itself. Obviously, opinions do not import a warranty, but there is an exception to this po, which is if the seller is an expert and his opinion was relied upon by the buyer. Expert opinion po may result into a warranty given by the seller. So, the following provisions po are not held to create a warranty. So, first, the usual exaggerations in trade when the other party had an opportunity to know the facts are not in themselves fraudulent under Article 1340. It is a natural tendency na po kasi for sellers to resort exaggerations in their product in their attempt na makabenta. Ito po yung tinatawag natin na dealer stock or sales stock by a seller which cannot ordinarily be treated po as a legally binding warranty. For example po is expression or advertisement ng isang pizza store saying something like this, this is the best pizza in the world. So, obvious naman na exaggerated yung phrase na yun and that it is just a mere sales talk and these usual exaggerations in trade po are not in themselves fraudulent. They are not construed as warranties kasi po the buyer knows that they are just mere exaggerations. Next, a mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the former's special knowledge under 1341. Ito po yung sinasabi ko kanina. To constitute fraud po kasi, the misinterpretation po must refer to facts and not opinions. So therefore, mere opinions do not import warranty unless made by an expert. Lastly, misrepresentation made in good faith is not fraudulent, but may constitute error under Article 1343. Dito po, if the misinterpretation is not intentional but made in good faith, meaning the person making the false statement believed it to be true, then it is considered a mere mistake po or error. For example, si a farmer and he found a ring and sold it to B. A honestly believed and represented to B na it was a diamond ring. It turned out na yung ring ay ordinary glass lang. So dito po, si A is merely nag-express lang ng opinion. Since yung misrepresentation was made in good faith, it is considered a mere error or mistake. Pero if si A ay expert and yung statement niya was relied upon by B, then it shall be construed as a warranty even if expressed in the form of an opinion. Next reporter.
Article 1547, Implied Warranty. Next slide. An implied warranty is not directly declared or expressed, but presumed to exist since they are considered a natural element of a contract of sale provided by the law. However, this may be waived or modified by express stipulation. The first paragraph is implied warranty as to the seller's title. The seller shall guarantee that he has a right to sell the thing to avoid eviction. The right of the seller to sell the thing is not necessary at the time of perfection of the contract. It is sufficient that the right will exist at the time that the ownership will be passed to the buyer. And the first paragraph also includes the implied warranty as to quiet possession, meaning the buyer is free from disturbance in the enjoyment of the property. For instance, walang third person na nakiklaim na mayroon siyang better title over the buyer. And the second paragraph is implied warranty against hidden defects or unknown encumbrance. The thing sold shall be free from any hidden defects. In addition, the seller shall be liable for the warranty even though he himself is unaware of the defect in the thing sold. This topic will be explained further in Article 1561. And lastly, implied warranty does not apply to, first, sheriff. It is a police elected officer responsible for keeping peace. Second, auctioneer. It is the person who manages an auction sale. And ito rin yung nagde-declare if sold na ang item at nagko-call out ng mga amounts of money that were offered by the bidders. And mortgagee. It is a bank or financial organization that lends money to borrower. And lastly, a pledgee. It is a person who receives a pledge of goods or property as a security. These persons enumerated are not liable to a person with a legal or equitable interest in the thing sold, because obviously they are not the owner of the goods, and they do not represent themselves as the owner of the goods. An additional note is the duration of the implied warranty is not less than 60 days nor more than 1 year under the sales of new consumer products. Next reporter.
Subsection 1, Warranty in case of eviction. Article 1548, eviction shall take place whenever by a final judgment based on a right prior to the sale on an act imputable to the vendor, the vendor is deprived of the whole or the part of the thing purchased. The vendor shall answer for the eviction even though nothing has been said in the contract of the subject. The contracting parties, however, may increase the means or suppress this legal obligation of the vendor. Article 1548 talks about that the seller guarantees that he has a right to sell the thing sold and to transfer ownership to the buyer who shall not be disturbed in his legal and peaceful possession thereof. Also, implied warranty against hidden defects or unknown encumbrance. Meaning of eviction. Eviction may be defined as the judicial process whereby by the vendee is deprived of the whole or the part of the thing purchased, by virtue of final judgment based on a right prior to the sale or an act imputable to the vendor. Warranties are national elements na kahit hindi sila na-mention sa contract, the assumption there are part of the contract unless otherwise stipulated. Eviction is the vendor should answer for the eviction even though nothing has been said in the contract of the subject. Next slides. Essential elements of a warranty against eviction. Pag na-evaluate yung warranty against eviction, the vendee or the buyer can do this. First, the vendee is deprived in a whole or a part of the thing purchased. If the seller guarantee na may right to transfer sa ownership and the legal possession ni buyer hindi madedesert, it will be a peaceful possession. And then eviction happen. Judicial process, if the whole or a part of the thing ay hindi pala properly transferred to the buyer because it already owned by others. Second, he is so deprived by a virtue of final judgment. Final judgment is in the judicial process, so meaning it is in the court. It is a final judgment or the last decision of the competent authority in this court, which either lasts 5 to 10 days. And it can have a appeal. It can have a appeal period if nag-apply siya ng appeal, and pag hindi naman siya nag-apply, magiging final na judgment. And then, third, the judgment is based on a right prior to the sale on an act imputable to the vendor. It depends to the case of the problem. For example, may lupa na binenta sa'yo, then nalaman mo after the sale, ay may ibang owner pala yung lupa. And he has a right also to the land. And fourth one, the vendor was summoned in the suit for eviction at the instance of the vendee. Yung right niya ay the vendee can summon the vendor the suit. Pwede niyang isama yung vendor sa suit. And then last essential is there is no waiver on the part of the vendee. There is no need in waiver in the part of the vendee. Pag nag-waive kasi siya, mag-isa na niya na lang i-deal yung problem at hindi niya may sasama yung vendor. Example of this is if Sheila sell a parcel of land to B, subsequently C files an action for the recovery of possession claiming that he is the owner of the land. At instance of B, S was summoned to the penny's title. And court renders final judgment declaring that C has a better right. Accordingly, V is evicted na. In this case, S is liable for B and for failure to comply with warranty against eviction. The judgment is based on the right on a third person prior to the sale. Next article. Article 1549, the vendee need not appeal for the decision in order that the vendor may become liable for eviction. Upon the decision of the court, for some instances, you can apply an appeal. In this case, no need to appeal for the part of the vendee. Pwede na niyang habulin agad as long as a final judgment. Pag walang nag-apply ng appeal, it is automatic a final judgment. Register na siya sa book ng court and also for execution na siya. Next article.
Article 1550. When adverse possession had been commenced before the sale, but the prescriptive period is completed after the transfer, the vendor shall not be liable for eviction. Article 1550 talks about the effect of prescription. First, ano nga ba yung adverse possession? Adverse possession meaning a person in possession of land na pagmamayari ng iba ay pwedeng maka-acquire ng valid title sa property. Next slide. Effect of prescription. By prescription, one acquires ownership and other real rights to the lapse of time in the manner and under the condition prescribed by law. In the same way, rights and actions are lost by prescription. If you acquire rights because of prescription, wherein to the lapse of time nagkaroon ka ng right, it is called acquisitive prescription. However, if you lose right because of the lapse of time, it is called extinctive prescription. Next slide. Now, if the prescription is completed before sale, the vendee may lose the thing purchased to a third person who has acquired title thereto by prescription. When a prescription has commenced run against the vendor and was already completed before the sale, the vendee can enforce the warranty against eviction. For example, may lupa na untitled, then may isang nag-claim na siya yung nakapwesto doon. Binakuran niya na pero iniwan niya yung property na yon. Tapos dumating ako na wala siya, which is naabandona na yung property ng ilang taon. So pumwesto ako pero alam ko na may talagang nakapwesto na doon. The prescription that is required in that situation is 30 years para mapasakin yung lupa. 30 years if it is in bad faith and 10 years if it is in good faith. So kapag nakompleto na yung 30 years, meaning sa akin na yung lupa, I acquired it by acquisitive prescription. Then, yung unang nag-occupy sa property, binenta niya yung lupa kay buyer. Now, the buyer can lose the thing purchased sa akin dahil may acquired title na ako by prescription of 30 years. Yung 30 years ay na-complete before the sale to the buyer. So, I can deprive the buyer of the property and yung hahabulin na lang niya is yung seller. Kasi nung time na binenta sa kanya yung property, ay hindi na talaga kay seller yung property na yon. Dahil doon, yung buyer ay pwedeng mag-enforce ng warranty against the seller. Next slide. Next, if the prescription is completed after the sale, even if a prescription has started before the sale but has reached the limit prescribed by law after the sale, the vendor is not liable for eviction. Same scenario, may lupa na untitled, then may isang nag-claim na siya yung nakapwesto doon. Then inoccupy ko yung inabandona niya for a while, tapos in the meantime na naka-occupy ako sa land, binenta niya kay buyer. Tapos yung buyer, nakita ako pero hindi niya ako pinaalis hanggang sa natapos yung 30 years prescription period. The vendor is not liable for eviction. Nung natapos yung prescription period after the sale, it is against the buyer na. The property was already sold to the buyer, so wala nang liability yung vendor because the vendee can file an action against sa akin para paalisin ako sa lupa pero hindi niya ginawa. So, negligence na ng buyer yon. Therefore, vendor is not liable for eviction. Next slide. Note, if the property sold, however, is land registered under the torrent system, and Article 1550 will have no application. Torrent system is a system of land title registration, and the rule of acquisitive prescription will apply only if the land is not titled. Wala pang titulo. Next reporter.
Article 1551, if the property sold for non-payment of taxes due and not made known to the vendee before the sale, the vendor is liable for eviction. Next slide. So here, what if the seller does not pay his taxes, and because of his non-payment of taxes, the property is levied upon and sold at a public auction? The seller will be liable. So dito po sa Article 1551, si vendor, binenta niya kay vendee yung lupa and hindi pala siya nagbabayad ng taxes. And because of his non-payment of taxes, si vendee was evicted from the property, or he was deprived of the ownership, and the property is levied upon and sold at a public auction because of the non-payment of taxes due from the vendor. Here, the seller or si vendor is liable for eviction. Again, this is an act imputable to the seller. But take note that para maging liable si vendor for eviction, this must not be known by the buyer before or at the time of the sale. Dapat hindi aware si vendee or buyer for him to avail of the warranty against eviction. Kasi of course, if the buyer knows, then the seller should not be liable. Siyempre, kung alam ng buyer yan na hindi nakakabayad ng tax dun sa real property tax yung seller dun sa lupa, edi siya na yung magbabayad kasi siya na yung may bagong may-ari sa lupa. Next reporter.
1552. The judgment debtor is also responsible for eviction in judicial sales unless it is otherwise decreed in the judgment. Next slide.
So Article 1552 refers to the liability of the judgment debtor in case of eviction and a judicial sale. First, let us define the unfamiliar words. A judgment debtor is the one who is obligated to pay debt or damages upon the order of the court. On the other hand, the judgment creditor is the person who is entitled to receive the proceeds of the property sold in a judicial sale. And judicial sale is a forced sale of a property required by the court in order to satisfy an indebtedness. For instance, the court attached the property of one to satisfy his indebtedness, and that property was sold in a judicial sale by a purchaser in good faith named Pedro. Subsequently, the purchaser was later evicted because it was found out that one is not really the owner of that property. In that case, the remedy of the buyer, or Pedro, is to recover the price paid with interest. If the sale is effected, then the judgment creditor will not be authorized to retain the proceeds of the sale. Next, reporter.
Article 1553. Any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. Sa Article 1553, na-waive yung warranty against eviction pero dapat in good faith siya para magkaroon ng valid waiver. However, the waiver of this warranty will be void if the seller was in bad faith. And how is the seller bad faith? If the seller had knowledge of facts which would give rise to the eviction at the time of the sale. Kahit may stipulation exempting you from eviction, you shall still be liable because you acted in bad faith. Pero kung yung buyer already knew these facts giving rise to eviction, then the waiver of the warranty will be valid. Next slide. Article 1554. If the vendee has renounced the right to warranty in case of eviction and eviction should take place, the vendor shall only pay the value which the thing sold had at a time of the eviction. Should the vendee have made the waiver with knowledge of the risk of eviction and assume its consequences, the vendor should not be liable. Next slide. So dito sa Article 1554, may dalawang klase ng waiver. Ito yung konsyente and intentionada. Kapag sinabing konsyente, the waiver is voluntary made by the vendee without the knowledge. So wala siyang alam, an assumption of the risk of evictions. So in that case, nag-waive siya, then di naman siya aware na meron palang risk of eviction, may problema pala. In that case, the vendor should pay only the value which the thing sold had at the time of eviction. Pero in intentionada, with knowledge naman si vendee sa risk of eviction and assumption of its consequences. Like aware siya na as a buyer, may problema pala yung papel ng property, yung titulo, may risk of eviction, pero tinuloy pa rin, nakipag-transact pa rin siya. So the vendor is exempted from the obligation to answer for eviction, provided he did not act in bad faith. Next reporter.
Article 1555 talks about the rights of the vendee to demand from the vendor when the warranty has been agreed upon or nothing has been stipulated in case eviction occurs. Article 1555 talks about yung mga bagay na pupwedeng i-demand ni vendee kay vendor once na nakaranas siya ng eviction sa thing na binili niya. 1. The return of the value which the thing sold had at the time of the eviction, be it greater or less than the price of the sale. In this case, the vendor can return the value greater or less than the price agreed during the sale depending on whether there is an improvement or deterioration of the thing. Example sa improvement, kapag yung subject matter ay lupa, pwedeng tumaas na yung value niya at the time of eviction, and kung ano yung presyo nun, yun yung kailangan ibalik ni vendor kay vendee. Example, si Vina ay yung vendee, tas si Larry yung vendor, tas yung napag-usapan nilang subject matter ng contract of sale ay lupa worth 500,000 pesos. And sumunod naman si Vina sa napag-usapan nila na magbabayad siya ng 500,000. Kaso, si Larry, binenta niya ulit yung lupa na yun worth 600,000 dahil tumaas na yung value nung binenta niya na kay Maria. Na kung saan pinaregister agad ni Maria sa pangalan niya yung lupa, kaya na-evict si Vina. Ngayon, may karapatan mag-demand si Vina bilang siya yung original vendee na ibalik sa kanya kung magkano na yung presyo ng lupa at the time of the eviction, which is 600,000 pesos na. Whereas, sa deterioration naman, pwedeng nagamit na kaya nag-deteriorate na yung value ng thing such as cars and phones. Kung magkano yung presyo ng thing at the time of eviction, yun lang yung ibabalik ni vendor kahit na nag-depreciate na yon. 2. The income or fruits if the vendee has been ordered to deliver them to the party who won the suit against him. Sinasabi dito na kapag daw nagbigay si vendee ng fruit or income dun sa nanalong party na may kaparehas na claim niya dun sa property, then kailangan ibalik ni vendor yung fruit or income na binigay ni vendee dun sa nanalong party. Because the vendee shall be free from any liability of the subject matter of the sale. Balik tayo dun sa example kanina. Nagkaroon na ng litigation para magkaroon ng eviction. Si Vina as the original vendee, si Larry as the vendor, and si Maria as the third party na may kaparehas na claim kay Vina. Ngayon, sa litigation na nangyari, pinaboran ng korte si Maria at inobligahan ng korte si Vina na ibigay yung lupa at income or fruits nito kay Maria. Dahil dito, kailangan din ibalik ni Larry kay Vina yung fruits or income ng lupa. 3. Cost of the suit. Entitled si vendee to recover the expense of litigation para magkaroon ng eviction plus yung cost of the action para ma-enforce ni vendor yung warranty. 4. Expenses of the contract. If nagkaroon ng stipulation na si vendee yung dapat magbayad sa expenses ng contract nilang dalawa ni vendor, which is contract of sale, that's the time na pwede niyang singilin si vendor. Pero kung wala naman, then hindi papasok yung expenses of the contract. Hindi niya pwedeng singilin yon. 5. The damages and interest and ornamental expenses if the sale was made in bad faith. Dito, hindi magiging entitled si vendee na mag-recover from the vendor ng damages, interest, and ornamental expenses kung nangyari naman yung sale in good faith.
Article 1556. Article 1556 deals with partial eviction. In this article, it states that if there is partial eviction, the vendee has the option to either enforce the vendor's liability for eviction or to demand the rescission of the contract of sale, while being obliged to return the property without other encumbrances than those which it had when he acquired it in the following instances. Next slide. The instances or situations when there is partial eviction: first, when the vendee is deprived of a part of the thing sold, if such part is of such importance to the whole that he would not have bought the thing without the said part. So kapag yung vendee ay na-deprive doon sa part of the thing na important or the main reason why the buyer bought the whole thing, therefore, if that said thing or part is subject to eviction, then hindi na bibilhin ng buyer yung whole thing. Also, there is partial eviction when there are two or more things, whether these things are sold for a lump sum or for a separate price for each, then the vendee would not have purchased one without the other. In this case, hindi bibilhin ng buyer yung isang property or object kung hindi kasama yung iba. If one of these is lost and the seller is evicted, then there is partial eviction. And here are the alternative rights of vendee in case of partial eviction, or the vendee's remedy. The first one is the rescission. The remedy of rescission is not available when it comes to total eviction. Dahil basically, kapag rescission, hindi na ibabalik yung object of the contract. And hindi ka makakapag-rescind ng contract if hindi mo na ibabalik yung object. But in case of partial eviction, the buyer can return your portion na natitira, and rescission can be allowed with respect to the subject matter which remains. And it is allowed because the buyer is able to return or restore yung portion. But apparently, the buyer can return the thing, but it must not be subject to other encumbrances than those which it had when he acquired it. Last one is the enforcement of warranty. Dito naman, ini-insist niya wherein hindi ma-cancel yung contract, but rather mag-enforce ka ng warranty or you will enforce the vendor's liability for eviction at magiging liable sa seller. An example for this article is A sells to B a parcel of land represented by A as containing 500 square meters at the rate of 200 pesos per square meter. So si B, papagawa siya ng factory and kakailanganin niya talaga is 500 square meter, nothing less. And B is evicted from a 20 square meter portion of the land. B would not have bought the land had he known of its smaller area. So under this case, B can either sue for damages for breach of warranty or demand rescission of the contract. He can also exercise his alternative rights if these were two parcels of land sold and he should lose one of them by reason of eviction. And that is Article 1556. Next reporter.
Article 1557. Article 1557. The warranty cannot be enforced until a final judgment has been rendered whereby the vendee loses the thing acquired or a part thereof. 1557 talks about two of the elements of the enforcement of warranty in case of eviction under 1548. Una, if the vendee experienced deprivation in whole or in part of the thing, kapag napagkait sa kanya or hindi niya nagamit in whole or in part yung binili niyang thing. Two, if there is a final judgment made by the court. Katulad ng example kanina, dahil nanalo si Maria, mapagkakaitan or hindi magagamit ni Vina yung lupa na binili niya. Yun, that's the time na mako-consider yun as eviction dahil napagdesisyonan ng court and pinaboran ng court si Maria imbes na si Vina. Next.
Article 1558. The vendor should not be obliged to make good the proper warranty unless he is someone in the suit for eviction at the instance of the vendee. Unless he is someone in the suit for eviction means at the instance of the vendee may request to the court that the vendor should be made a party to the action for eviction by being a codependent. Bakit kaya kailangan mag-participate ni vendor? Because obviously, siya ang makakapag-depend ng right ng buyer to the peaceful and legal possession of the property. Siya naman kasi ang nakakaalam kung anong nangyari, so he must appear or he must be summoned at the instance of the vendee. Ang object ng law dito is to give the vendor an opportunity to intervene or makialam to defend yung title na transfer niya dun sa buyer. Kasi nga, siya naman talaga yung tunay na nakakaalam kung ano talaga ang nangyari. So, he is in the best position to defend the validity of the title. And if there is no opportunity given to the seller to defend the title, which he has given to the buyer, he is not bound by his warranty. Isang sample dito is yung kapag may binenta sa yung bahay, tapos hindi mo alam na may right prior sa sale sa'yo, tapos pinapaibig ka ngayon ng nauna, pwede mong isama or isummon yung seller mo as a witness, then pwede mong i-waive lahat ng implied warranties mo. Next article. Article 1559. The dependent vendee shall ask within the time fixed in the rule of court for answering the complaint that the vendor be made a codependent. Vendor is to be made a codependent. Parang katulad lang to ng Article 1558. Buyer should call in the vendor to defend the action which has been instituted against him. Pwede niyang i-ask yung court with the time allowed for him to answer na maging codependent niya yung vendor. Para dalawa na silang mag-answer dun sa complaint ng third person. Next reporter.
Article 1560. In this article, we will talk about servitude or easement. So, servitude or easement is an encumbrance. This is a burden upon a property for the benefit of another immovable belonging to a different owner. So, take note, apparent servitude is yung obvious na burden siya sa immovable property. Halimbawa, yung lupa na kinatatayuan ng bahay nyo, is nasa looban. So, wala kayong access sa highway kasi nasa bandang likod siya. Tapos, sa dalawang gilid ng property nyo is bangin sa magkabila. So, you cannot access the road. Yung property sa harap nyo is yun yung easement. That is the right of way. Yung property sa likod is called master estate. So, siya yung pinagsisilbihan ng servient estate. So, yung servient estate, nasa kanya yung right of way, nasa kanya din yung burden. So, yung servient estate will now serve the master estate. So, para makapunta ng highway, yung mga nakatira sa master estate will cross on right of way that burdens yung servient estate so that they can go to other places. If may sign or visible yan, it is called apparent servitude. So, halimbawa naman, same road, same right of way. Let us say matagal nang walang nakatira sa likod tapos yung dinadaanan is puno na ng damo-damo or wigs ganyan. So, hindi nahalata na may daan doon. So, this is obviously not apparent because it is not continually kept in view. So, it is called non-apparent easement. So, next slide. Here in 1560 naman, nakabili yung buyer ng isang property with an easement. Ang nabili niya is servient estate. Tapos, nung nabili niya yung servient estate, there is a non-apparent burden. So, hindi niya nakita na meron palang easement. So, ang remedies niya ay buyer may ask for rescission or ask for damages. So, remember here that the buyer is not actually deprived of the property he bought except nasa kanya naman yung property. Kumbaga, hindi naman siya na-deprive fully or partially, but he can ask for rescission or seek damages because non-apparent siya non-apparent burden were not usually mentioned in the contract, di ba? Siyempre, kung alam lang ng buyer na may ganito, hindi niya sana bibilihin yung property, di ba? Also, the lack of knowledge on the part of the vendor is not a defense. Here, the contract can be invalidated or rescinded on the ground of mistake. Next slide. When remedies were not applicable naman, the remedies here is not applicable if the servitude or burden is apparent. May karatula na ngang right of way, binili mo pa, di ba? So next, the registration of burden of easement is ginagawa sa registry of deeds, so it operates as constructive notice to the buyer. So nakalagay naman sa titulo na mayroong or nakarehistro doon sa titulo na mayroon siyang easement or servitude. Even if it is not apparent, di mo nakikita. But dahil nakalagay nga siya sa titulo, obviously, if the burden or servitude is known by the buyer, there is no warranty. So dahil nga nakarehistro, there is a constructive notice or parang pinapaalam na sa buyer even if hindi naman talaga. But this is a constructive notice operates as a knowledge of the vendee which will equate to no warranty. So the third one is the actual knowledge of the vendee. So, alam niya na talagang daanan whether register or not. So, bakit niya pabibilhin, di ba? So, with this, in this case, the remedies are not applicable. Next one. When action must be brought. So, the action for rescission or seek for damages must be brought within 1 year from the execution of the deed of sale. So, if yung period na yun is lumipas na or tapos na, the vendee may only bring an action for damages within 1 year from the discovery of the non-apparent burden or servitude. So that would be all for the group 2. Thank you for listening and God bless us all.